Suppose that a buyer breaches a contract for the sale of goods by notifying the seller that it no longer wants the goods. If the goods are unfinished, the seller has various options under Section 27042 of the Uniform Commercial Code, or UCC. Whatever the seller ultimately decides to do, the decision must be commercially reasonable. But who bears the burden of proof for commercial reasonableness, the buyer or the seller? Ohio's highest court faced this question in Young v. Frank's Nursery and Crafts. In the late 1980s, Frank's Nursery and Crafts ordered 360 tons of evergreen boughs from William Young. In preparation for carrying out this order during the upcoming fall cutting season, Young obtained cutting rights from tree farmers, repaired his machinery, and made 75 hand tires for bundling the boughs. But at the end of June, Frank's reduced its order to about 70 tons of evergreen boughs, effectively cutting the contract price by about $178,000. Young tried to find other buyers for the boughs that Frank's no longer wanted, but everyone he called had already placed their fall orders with other sellers. So when fall came, Young cut only enough evergreen boughs to fill the reduced order from Frank's. Young sued Frank's for breach of contract in Ohio State Court, seeking to recover lost profits. Frank's admitted liability for breach of contract, contesting only damages. The trial court instructed the jury that, to stop Young from recovering his lost profits, Frank's needed to prove that Young's decision not to cut all 360 tons of boughs was commercially unreasonable. The jury returned a $132,000 verdict for Young, and Frank's appealed. The Intermediate Appellate Court reversed, reasoning that the trial court had wrongly placed the burden of proving commercial unreasonableness on Frank's. Young appealed to the Ohio Supreme Court.